The most important provisions in a drilling contract depend to some extent on what kind of drilling contract. If it's a short-term drilling contract, then the most important provisions probably relate to risk allocation, indemnities, insurance, release for claims, because the ability to control performance is largely controlled by the ability to terminate immediately after that one well is over. If you have a long-term drilling contract, particularly offshore where the rates are higher, then the ability to control performance, mandate good performance, suspend if there's not good performance, and terminate becomes critical for both sides. The drilling contractor wants to make sure that its revenue was unending for whatever term the contract has, and the operator wants to make sure that it only pays if it gets the kind of performance that it intends to get. So you have a variety of provisions in the drilling contract that relate to performance. You have a repair rate that governs instances in which the rig is down for one reason or another, and so that gives some respite to the operator in the event of poor performance of the rig. The problem from the operator's standpoint, as respects the repair rate, for example, the repair rate should go to zero, but the operator is still paying about the same amount as the day rate for the spread rate, the other contractors that it has on location. So the rig may be at zero rate and the operator may still be paying an awful lot of money. So being able to control performance becomes very critical in long-term drilling contracts. In short-term drilling contracts, there's a huge amount of risk allocation in a typical drilling contract. The indemnities are usually almost always based on regardless of fault, or what I call a status indemnity, and each party indemnifies the other regardless of fault for the risks that they take, unless there's an exception. So for example, it's very typical in a drilling contract to have a broad reciprocal indemnity, or knock for knock, in which the operator is responsible for indemnifying for any claims by its people for bodily injury or death, for loss or damage to its property. For all of that, it's intended to indemnify the drilling contractor regardless of the drilling contractor's negligence, and in some instances regardless of its gross negligence. That's a disputed provision, as you can imagine. In addition, the drilling contractor will basically take the position that, look, the operator's bringing on a lot of other contractors to help drill the well. They're on the drilling contractor's drilling rig, and so the operator's required to indemnify for them as well. The drilling contractor takes its people and its property, regardless of fault, and its subs, but typically it doesn't have any subs. So that's somewhat of an illusory benefit to the operator. But the protection for the damage to the rig is huge, and the drilling contractor has a large number of crew members depending on the kind of drilling rig you're talking about. So the initial risk allocation provision is set up on this basic broad reciprocal, and that's driven by the drilling contractor typically and applies regardless of fault. That does two things. One, it means that the operator is going to be responsible anytime anybody gets hurt other than the drilling contractor. So it becomes critical for the operator to set up an indemnity structure in which, when it brings out somebody to do a well service, that well service company indemnifies not only the operator, but also the drilling contractor, because the operator owes indemnity to the drilling contractor if the well service guy gets hurt. And if you can imagine a structure in which each contractor has to then indemnify the operator and the operator's other contractors, that gives you some idea of the indemnity structure that the operator has to set up so that it doesn't get caught in the middle. If the operator can make all the right indemnity obligations in its underlying contracts, and there's no solvency issues, and all the contracts are enforceable, then in theory, whatever the operator owes the drilling contractor for any of the other contractors will be backed up by the indemnities in the other contractors' contracts. Right. But it puts pressure on the operator for everything to work properly. And in domestic U.S., there are a number of anti-indemnity statutes and other legal issues that affect enforceability. So the operator can get stuck in a situation where the indemnity it owes to the drilling contractor is enforceable, but its backup protection from the other guy is not. And that's another way to get stuck in the middle. So the big ifs are solvency, enforceability, and kind of contract administration. The other big issue that you have from a risk allocation standpoint is what I call carve-outs. Some of the carve-outs have sort of come about historically because the operator was considered to be in control of what happens below the surface. So if there's loss or damage to the drilling contractor's tools while they're down hole, even though it's contractor's property, the operator is typically responsible to some extent or another. There may be an exception for negligence or sole negligence or gross negligence. There may be an exception for defect in the tools, but generally the operator, if there's no way to know what happened, the operator takes responsibility, and it's very expensive for the drilling contractor to get coverage for those downhole tools. But similarly, the operator is also expected to cover downhole tools for all of its other contractors. So it ends up with a lot of risk in the form of downhole tools that is typically not insured or insured with very high deductibles. That's an historical carve-out that's existed for a long time in the industry. Another carve-out is for pollution from below the surface. Typically, the split is that contractor takes pollution from its equipment above the surface, and the operator takes responsibility for pollution from the well. And you also have the operator typically take some responsibility for well control and cleanup and removal of pollution from a well control incident. The big fights that you have, particularly these days, is that drilling contractors want to be protected not only for additional expenses from those risks, such as cleanup and removal of pollution, but also all third-party claims. Following the Deepwater Horizon event, it was evident that the third-party claims, particularly offshore, can be very significant. So drilling contractors press for not only coverage for certain aspects, but for all claims by any third parties. And in fact, it's not uncommon to have what they call a catastrophic loss provision, which basically I call the something bad happens provision. If something bad happens, the knock for knock is off and operator pays for everything. That is the preferred drilling contractor approach. Now, essentially the best way for the operator is to go through and kind of parse that out and say, okay, if it's a well control event, I'll pay for well control but not third party claims. Those ought to be at law. If it's a pollution event, I'll pay for cleanup and removal but not third party claims. And that will be kind of the battleground. Another big issue is, and it's a very big issue for the operator, is a carve out for loss or damage to the drilling rig. So for example, the drilling rig is something that the operator absolutely expects the drilling contractor to be responsible for. But the typical IADC drilling contract, which is a form created for drilling contractors, has some carve-outs. One carve-out is for the sound location. And if there's a problem with the location, the drilling contractor says you need to take some responsibility. And if it in fact is the operator's responsibility, it's not uncommon for the operator to take some responsibility, usually up to a cap. And in the days when insurance was a little more affordable, it would be a cap up to the deductible in some instances. Unfortunately for the operator, in the drilling contract form, the IDC form, there's some pitfalls because the provisions in, say, the indemnity articles say that the sound location provisions apply regardless of fault and end up making the operator responsible for damage caused by a sound location even if it was the contractor's sole negligence, which is clearly not what the operator intends, although the drilling contractor would like it. So there's a lot of issues around sound location. Another big carve-out that's become more and more prevalent is the helicopter vessel carve-out in offshore drilling contracts, in which the drilling contractor basically says, look, you take your group, your indemnity, and I'll take my people and property and subs, but I don't want to indemnify you for damage caused by one of your helicopters or vessels because I'm just sitting there in the ocean. That's the argument. The counter argument is, look, that's the one place where I really need that indemnity as the operator, because my helicopter contractor won't take damage to the rig. My vessel contractor won't take damage to the rig. There are lots of instances in which I indemnify you for causing a blowout that may have been all your fault and I still have to pay for it. So you can't say, let's do the broad knock for knock and then carve out all the different possibilities where I might really need the indemnity, because it's not a fair trade. And so you go back and forth on that, and you can compromise it. It should never be done without a cap. If you can reach agreement on a cap, that's a reasonable possibility. One final huge issue for a drilling contract using an IEDC form, which is the International Association of Drilling Contractors form, is that the drilling contract is set up as a broad reciprocal. So it says, operator takes responsibility for its people and its other contractors. Drilling contractor takes its people and its subs. But the indemnity that operator is owed only runs to operator. So what happens? If one of the well service contractors has negotiated a broad reciprocal, which when things were going great was very, very common, the well service guy accidentally blows up the drilling rig. The drilling rig can't sue the operator, and the operator hadn't done anything wrong. But because it only indemnified the operator and not operator group, it can sue the well service contractor. And it can get the value of the rig from the well service contractor. And what does the well service contractor do? He turns around to the operator and says, look, that was one of your other contractors suing me for their property damage, so now you have to owe me indemnity. Bad for the operator. So there's a lot of interlocking indemnity issues in the risk allocation provisions. We haven't even talked about insurance. All of these ought to be backed up by insurance. The insurance ought to basically dovetail with the risks assumed. You have to make sure that the additional assured protection is limited to the risks assumed by the party giving the protection. You have to be careful about restrictive additional insured endorsements, because domestically some of the provisions may be enforceable for insurance but not enforceable for indemnity. So you need to make sure that they cover the same things and that they extend to the same people, the groups, the broad groups of company group or drilling contractor group.